Let me bring in Faizan Mustafa, legal scholar and former Vice Chancellor of the Nalsar University of Law in Hyderabad. Many thanks for speaking with us. First of all, Gujarat is the next state after Uttarakhand to form a committee to implement UCC. But wouldn't UCC be in contravention of the constitution that guarantees certain religious freedoms in the country?
While Article 25 and 26 do talk of freedom of religion of all human beings. It is not confined to just Indian citizens. And that shows the broad-mindedness of the members of the Constituent Assembly that anyone who is in India, whether he is an Indian or a foreigner, has an equal freedom of religion. Then there was a debate that should we also include within right to religion an exception that the state will not impose a uniform civil code or would protect personal laws. Such a proposal was mooted in the Constituent Assembly and it was rejected.
Okay.
And subsequently, uniform civil code provision was included in the directive principles, which you know are not justiciable. Nobody can go to the court of law if the government does not implement directive principles. There are many directive principles which are in fact not talked about. And today I would say that the foremost amongst them is that there should be no concentration of wealth and the national resources should be so distributed as to subserve the common good. But you know, 1% people in India are having over 70% of wealth. We have talked about only two directive principles, the cow protection provision and the uniform civil code. Having said that, I would say that we should still go to the entry number 5 of the concurrent list, where the framers of the constitution have really put the personal laws. They have not given this power only to the parliament. Had the intention being to have just one law, it should have been included in the union list. Okay. The mere fact that the personal laws are included in the concurrent list means that different states can have different personal laws.
Okay. Okay. But Faizan Mustafa, if the idea of bringing the Uniform Civil Code is noble to create gender parity, for instance, as is argued by some, then and if it's not a political move, shouldn't this move be staggered to bring in certain contentious issues under uniformity, like for instance maintenance, adoption, inheritance?
I have consistently been writing on this, that if you go for uniform civil code, as Professor Bernard Mensky had written, that should you abolish polygamy even if there is bloodshed, and his answer was no, you shouldn't do it. So if uniform civil code in one go is going to polarize our society, to create unnecessary disputes in the society, I have been writing on this and my position has been consistent position that reforms in personal laws should be done in a piecemeal way. As you are saying that in one go we can reform the maintenance law, then the marriage law, then the divorce law, then the inheritance law. It is better to do it in small doses rather than coming up, a wholesale reform in one go, which are very difficult. It is always easy to reform the laws of the majority. And that's why the Muslim countries were able to reform Muslim laws, but Pakistan, for instance, was not able to reform the Hindu law. And in India, Pandit Nehru was able to reform the Hindu law, but was not able to reform the Muslim law because he said, let the initiative of the reform should come from the community. But I think if the community is slow in responding, then the government will be within its rights to set up a committee, but that committee should consist of real scholars of that subject.
But Faizan Mustafa, since there are apprehensions, can such a move be challenged in court? Is that even possible legally and constitutionally?
Anything about directive principles will not be accepted by the court. You know, number of petitions have been filed in the court and the court said we cannot give the directive. Recently, the government of India filed an affidavit and the Ministry of Law and Justice of the Union Law Ministry has taken a position that this is a directive principle. The prerogative is of the parliament. You see, since Article 44 is also saying that a uniform civil code will be for all citizens throughout the territory of India. How can one state pass a law which will be applicable, say, in the neighboring state of Maharashtra or Madhya Pradesh? So if at all, and that has been the consistent position of the BJP, except during Vajpayee's government when they left out three contentious issues of Babri Masjid 370 and UCC and had put them in cold storage, BJP's consistent position has been that we want a uniform civil code. And therefore, if they set up a committee or they make even it a political issue, I think they are justified in doing that. My problem is how come the minorities on their own and the Muslims organizations or the Muslim Personal Law Board has not all these decades taken any initiative to do the internal law reform. Say if the government today asked them to draft a code of their choice, it would be very difficult for them to put up a draft. There is a draft, what kind of changes Muslims are willing to do it, because there are many reforms which can be done by remaining within the Islamic fold. You have liberal schools and you have regressive conservative schools. So on many things, if you do inter-school borrowing, you would be able to do some substantive reforms within the Muslim law. So that has not been done. So I would also blame the Muslim community and the Muslim leadership for not taking initiative. Just opposing uniform civil code, will not help, because once the provision is there in the constitution, you can't delay it, forever.
All right.